Hello, everyone. In this video, we're going to discuss the California Family Rights Act leave law, and which now extends to all employers in California who have 5 or more employees, and just goes through some of the basics that many of my clients have been wondering about. This law applies now in 2021 to all employers with 5 or more employees. It provides 12 weeks of leave for a qualifying reason. It's unpaid, but the employee may potentially qualify for employer benefits like paid time off or vacation, or other state benefits like disability or paid family leave. It's only available to employees who meet certain length of service requirements. An employee has to have been employed for at least 12 months during the previous 7 years. So they could have come and gone from the employment, but it needs to total 12 months. And they have to have been employed for at least 1,250 hours during the 12-month period immediately preceding the commencement of their leave. So that's actual hours worked rather than just time in the employ of the employer, but that they might have been off for some other reason. These are the qualifying reasons for a leave: an employee's own serious health condition, which is an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical care facility, or continuing treatment by a healthcare provider. It also includes permanent and long-term conditions that require ongoing medical supervision. A serious health condition of a family member is another qualifying reason. The birth of a child and to care for that child, commonly referred to as baby bonding leave, is provided for by the CFRA. Placement of a child with an employee for adoption or foster care also qualifies. And then also a qualifying exigency arising out of the fact that an employee's family member is on active duty in the armed forces. Family members under this law include parent, child, spouse, or domestic partner, siblings, grandparents, grandchildren, and I've got domestic partners on there twice. Documentation that is required is important when you're talking about CFRA leaves of absence, because it gives an employee notice of whether or not you're going to count the leave toward their allotment. When foreseeable, an employee request leave within 30 days advance notice to the employer. So this would be for a non-urgent procedure that the employee needs to have done, but that's being scheduled out in advance, for example. If possible, they need to give you 30 days advance notice. Once an employer receives notice that an employee has a qualifying reason for CFRA leave, they need to provide a notice and a designation form about how the employer is going to treat that leave within 5 business days. A request doesn't have to be formal and in writing. It can just be noticed to the employer verbally that the employee needs time out for leave. Often, for example, if an employee is suddenly hospitalized, they're not going to turn in a written request for that. And then if you're going to request a certification of a healthcare provider pertaining to the leave, the employee should be given that documentation at the outset of the leave and then given 15 calendar days to respond. I just wanted to go through a brief example of why it's important to track this leave and other leaves and how they interact. So here on the top, we have the FFCRA, the Families First Coronavirus Relief Act, that provides for 2 weeks of leave, or it did last year, and it's voluntary now until March 31st. But as an example, it provides 2 weeks of leave for the employee's own health condition. If an employee is hospitalized for COVID, for example, that would also qualify as a serious health condition under the California Family Rights Act. So those two can run concurrently. So the employee would use their 2 weeks of FFCRA leave at the same time they're using 2 weeks of CFRA. Now, for example, this employee becomes pregnant and she takes a standard 8 weeks off for the 2 weeks before the baby is born and then 6 weeks after to recover from a standard delivery. So she has 8 weeks off of pregnancy disability leave. Pregnancy is excluded from the California Family Rights Act because we have this separate pregnancy disability law. So CFRA doesn't run during this period. But then she finishes her 8 weeks, period of disability recovering from that birth, and she wants to do 10 weeks of baby bonding. She wants to use the rest of her CFRA leave. So then that 10 weeks would begin to count from that point forward. So this is how these overlap. If the employee, for example, only elected to use 4 weeks of baby bonding, or she elected to use it intermittently, perhaps, and she started out with 4 weeks, and then she develops another health condition, it's important to track these and determine how much time there is and to give the employee the proper notices so they're aware of how you're counting it.